permitted in the same way as any other kind of a testing facility. Now, one thing that's a little odd is this new statute that was just adopted in December that extended the various deadlines. The one other little piece of tinkering that the legislature did was it declared that a marijuana cultivation facility is not agriculture. Okay, so many of you probably are aware that agriculture uses have all kinds of special protection under local zoning, and essentially they are permitted by right in all districts if they have 5 acres, or I guess it's 2 acres plus they make $500 a year. There's a great long thing. Definition of agriculture includes aquaculture, which is a lot of marijuana cultivation facilities use aquaculture. So it seemed to be a concern of the legislature that marijuana cultivation facilities should be cut out of the definition of agriculture. So they did that. Sadly, what they did not do is tell us if it's not agriculture, what is it? So I will say, kind of looks like, these are generally sort of large warehouse type buildings with grow lights, so it kind of looks like manufacturing a little bit, but they didn't tell us what it is. So I don't really know whether a cultivation facility is necessarily permitted under anybody's zoning bylaws today or not. We'll have to leave that for determination as we go along. Okay. Now we come to the biggest mystery of all in the statute. The statute says that local governments can adopt an ordinance or a bylaw that prohibits one or more types of marijuana establishments. So at the moment, I am assuming that types means cultivation, manufacture, retail, testing. It's not defined in the statute that way, but that's sort of the sensible. So you can prohibit one or more. Some of my colleagues have said one or more does not mean all, but I'm happy to say it probably. I'm willing to say it probably does mean all. So you could probably prohibit all 4 if you chose to do so. Or another thing you can do is you can limit the number of marijuana retailers to fewer than 20% of the number of package stores you have in town. So, the number of package stores you have in town is based on your population in a town that permits package stores at all. So you can limit it down to, you can limit the number without this sort of weird process that I'm about to talk about. But if you limit it down to lower than 20% of the number of package stores you have, you will have to go through the vote of the voters. And then the last thing that you can do, you can limit the number to fewer than the number of medical marijuana treatment centers. So this is probably only of much interest in Pittsfield, where they're likely to have 2 or 3 treatment centers if they continue to exist. And so if Pittsfield, for example, decided it wanted to limit the number of marijuana establishments to fewer than that, it could do so, but it's going to have to require a vote of the voters. So many municipalities that I have worked with take the position, we voted against question 4 in our town, so we want to prohibit them, or we voted for question 4, but we didn't mean that we really want pot shops in our downtown business district or really anywhere, so we'd like to prohibit them. And you can do it. The statute says you can do it, but it requires you to do something that they neglected to define, and that is that you must have a vote of the voters. So, I'm going to tell you now what my best guess of what a vote of the voters means. I believe that in towns that have open town meetings, the vote of the town meeting is a vote of the voters. So you just adopt your zoning bylaw or your general bylaw, whichever you decide to do, that prohibits retail establishments or growing establishments or all of them, whatever. And you just do it in the normal way that you would adopt any other kind of a bylaw at an open town meeting. In towns that have representative town meetings and cities that have city councils, a vote of the voters seems to not include vote by somebody who's a representative. So it appears as though in those locations you need a ballot question. Now, I will tell you that that's my interpretation. And here's the reason for my interpretation. Number one, we have a whole lot of statutes that tell us how we can adopt bylaws that are quite specific, and nothing in this statute suggests that those procedures were supposed to be repealed. Number two, later in this statute, there is a provision that talks about a ballot question in quite specific terms, the way you would normally see a ballot question presented. It tells you right in the statute what the ballot question is supposed to look like. That doesn't appear here. That suggests that a ballot question isn't always required. And then the third thing is that we have always accepted the proposition that our town meetings, that at least our open town meetings, are the will of the voters. It seems highly disruptive of our local government process to suggest that there is some other way to adopt a bylaw other than going through town meeting. So this is my interpretation. I'm sticking with it till somebody says otherwise. Of course, there is no case law here. There's no regulation. There's nothing. This is just Ray Miyares says this is what this means. And I should tell you that almost none of my colleagues agree with me. So there I am. Most of my colleagues believe that a ballot question is required whenever a limitation is, one of these three kinds of limitations is going to be adopted. I have argued valiantly on our listserv of town council listserv, but so far I haven't managed to persuade anybody, but maybe I'll persuade you. The debate, the real debate seems to be whether the ballot question needs to say town meeting is authorized to adopt a prohibition, or if it happens after the town meeting has already done it, the prohibition that town meeting adopted is hereby ratified. Does it need to be of that form? Or does it need to say, shall the town adopt the following bylaw? It's much the way that the initiative petition adopting this statute was done. There seems to be a big debate going on about that. Nobody seems to be taking the position that I took, which is that for towns with open town meetings, none of that's really necessary. So we'll see. There have been no prohibitions adopted so far. As you probably are aware, when a town adopts a bylaw, it has to go to the Attorney General, and the Attorney General has to approve it. So that includes not just the substance of the bylaw, but the procedure by which it was adopted. So if these prohibitions do in fact get adopted, and I know one of the towns that I serve is planning to put one on their spring town meeting, and it's a representative town meeting, so they're going to do a ballot question. If I've done it wrong, we'll find out. But for now, it's a little almost embarrassing that I had to write at the top of this that this was my best guess. But as I indicated, there's a lot of guesswork involved. Many towns, therefore, are considering doing a zoning moratorium. So many of your towns probably had zoning moratoriums for medical marijuana when we were in this essentially identical situation a few years ago, where we were required to authorize medical marijuana facilities, but we didn't have any guidance from the state. So the trick here is, instead of prohibiting things permanently, you prohibit facilities for a period of time. During that time, you do a study where you try to figure out what you're going to do, but most importantly, it means that you're adopting, you get the advantage of waiting until after the state has promulgated some regulations that ought to help us some. The Attorney General has now approved one such moratorium for the town of West Bridgewater, which therefore has done me a great favor. I never, ever, ever want to be first on anything. I want someone else to do it, and then I'll copy it. Because then I know what will and will not get approved. Happily, the town of West Bridgewater didn't share my foibles, so they went first. The Attorney General has approved it. The Attorney General ruled that a moratorium is not a prohibition. You might think it's a prohibition because it prohibits these facilities, but it only does it for a short period of time. So she has said it's not a prohibition. That's fine. That's the same thing she did in the medical marijuana field. The other thing that is necessary is that a moratorium needs to be for a specified and limited period of time. So the one in West Bridgewater is until, I believe it's June of 2018. That's not a bad amount of time. What I would suggest is that if you're going to go down this road, that you pick a moratorium length that is 1 year plus 90 days, and then maybe a few extra days just for slippage. The point being, in your Springtown meeting, you adopt the moratorium, and it gives you essentially a year to figure out what you want to do. A year later, you adopt whatever it is that you're going to do, if you're going to do something, and you have 90 days to submit it to the Attorney General for approval, and therefore, in the meantime, the moratorium remains in effect, and the new bylaw will be able to go into effect in a sort of orderly fashion with no gaps. It is true that zoning bylaws are sometimes retroactive to the time of the notice of the public hearing. That might cover you, but that only helps you if there is an actual permit involved. Remember, a marijuana retailer might not need any kind of a permit locally if all they're doing is, next to bread and milk, we're now offering marijuana. No building permit would be needed, no anything would be needed. So I'm not comfortable just relying on the retroactive effect of zoning bylaws. I think you need 15 months, maybe 16 months. If you try to go longer than that, last time around I did manage to persuade the Attorney General that a medical marijuana moratorium that was 18 months was okay. But she wasn't very happy about it. So You probably could get away with 18 months, but you probably don't need 18. So 15 or 16 is probably what you need, and you should go for that. So the two moratorium bylaws that I have written for the towns of Hopkinton and Reading both have expiration dates of August 31st, 2018. Okay, so next up, some of you may have been to Amsterdam, and you may be aware that in Amsterdam, a very popular thing are the marijuana cafes, where you can go in, you can buy a supply, and you can consume it right on the premises. That is not currently authorized anywhere in Massachusetts. However, cities and towns can permit it. This one clearly must be done by a referendum. As I mentioned before, this is the part of the statute where they specifically laid out what the ballot question needs to say and how it's going to work. They specifically said it can only occur at a biennial state election. So those are the elections, every 2 years on an even number of years when we either vote for president or we vote for Congress, and we also vote for our Senate, senators and representatives, our local senators, our state senators and representatives. That's the only time you can do it. It's got to be one of those elections. If you have your town elections in May, as most towns do, or in the spring, as most towns do, that election doesn't count. You can't use that one. You must use the one that's in November. And it says something peculiar. It says that it requires a petition of 10% of the voters of the city or town to initiate that. It does not acknowledge that in most circumstances a ballot question can be voted to put on the ballot by your board of selectmen or by city council mayor in a city form of government. This statute doesn't seem to be aware that that's an alternative. So it seems to say that this particular ballot question has to be initiated by a petition of the voters. I wouldn't be surprised to see this one tinkered with when the legislature gets around to tinkering, but that's what it says today. So if instead of being interested in prohibiting things, you're interested in encouraging things, this is the way to go. Okay, so the town can adopt a local option tax. There's no information about what it needs to look like. I would prefer it to be a bylaw or an ordinance that sets forth what the tax is, but the statute doesn't specifically say you have to do it that way. It just seems to say that the town can vote to do it. Maximum tax is 2%. If you're looking for a new revenue stream, this one seems like it's a possibility. This isn't going to make anybody rich, but in any case, 2% is 2%. All right. So we generally say marijuana is now legal. But as this chart shows, it's legal some of the time. So this one is about cultivation. If you have a license, it's legal. If you don't have a license, you're limited to 6 plants per person or 12 plants per household. If you cultivate more than that, up to 12, it appears to be subject to the civil penalties that pre-existed. And the state says that you're also subject to having your marijuana forfeited. Beyond that, there are criminal penalties, or if you're juvenile, delinquent penalties. So it's cultivation is permitted, but keep in mind it's not under all circumstances. Same thing with possession. If you have a license you can have any amount. If you don't have a license but you're over 21, then under an ounce is legal. 1 to 2 ounces is still subject to the civil fine that it currently exists, and over 2 ounces is still a crime. If you're a juvenile, you have a civil fine of $100 and a mandatory drug education program. And if you have more than an ounce, you're subject to delinquency proceedings. And finally, if you're just in the distributing business, this is the really important one. This is intended to shut down the black market in marijuana. So if you're over 21 and you have a license, then it's legal. If you're doing under an ounce, you can share it or sell it if it's under an ounce, and it's still legal. Otherwise, it's subject to criminal penalties or civil fine, and obviously if you're a juvenile, delinquency proceedings instead. Okay, so questions? Who wants to be the picker?
My question has to do with selling. We're a border town, and we're in Egremont, and so New York State is, 4/10 of a mile from where I happen to live. And what about selling to out-of-state people? Are there any prohibitions, anything in this law about that?
The law is silent. I would interpret it to mean that sales are sales. It doesn't matter to whom you sell it. The person who's coming from New York and buying it in Egremont and then taking it back to New York presumably is going to run into trouble with the state of New York, but that's not our concern. There is nothing in the statute that talks about who you can sell it to. Over here.
Early in your discussion, when you talked about restrictions that municipalities could place on marijuana facilities, you talked about prohibiting or not prohibiting. What about the situation of limiting, say, retail sales to certain zones?
I think that is permissible. A zoning bylaw or ordinance that says retail facilities are only permitted in the whatever district is not a prohibition, and it doesn't limit the number, so I think that could be adopted in the ordinary way and shouldn't cause any problem with the Attorney
Can you
General.
subdivide retail facilities? In other words, if retail is permitted on your downtown Main Street, can you say that continues, but retail marijuana can only be sold in an industrial district?
Absolutely. I mean, the best analogy I can think of is tattoo parlors. Many zoning bylaws have special provisions that limit tattoo parlors, or I guess adult bookstores is another one, to just certain retail districts or certain districts, not the main retail district down in the center of town.
Thank you. And on your last slide, when you talked about distribution, you referred to gifting or the intent to gift. What about sales? Can mom and pop who grow 12 plants sell those?
If mom and pop sell their 12 plants without a license, they're in trouble.
So for sale, you need a license, but mom and pop can give it away for Christmas.
Exactly.
Thank you.
And I will be looking in my stocking. Back here.
Yes, good evening. Thanks for helping out and clarifying a lot of these things, but I have one question of clarification. You had mentioned early in the presentation the number of plants that could be cultivated as 6, but in the statute it says up to 12.
per household.
Per household.
Six
but
per person.
Right. So could you clarify that a little bit? Is it 6 or 12, and how is that distinguished?
It's 6 per person, 12 per household. So if your household has more than 2 people, you're still limited to the 12.
Okay.
And you're going to have to fight over who gets the
Okay.
who gets the plans. In a household where, let's say, the millennial is living in the cellar, he might actually be getting all 6. I don't know. We'll see.
Okay.
If it's a one-person household, it's per person and per household. So if you don't have 2 people in your household, you just get 6.
Just 6, okay.
Yes.
Another question, too, is on the prohibition question. Does it require 2/3 vote or a simple majority?
If you are
town meeting.
if you're adopting a zoning bylaw, which is what I would imagine most towns would be doing, then it would require 2/3, just like any other zoning bylaw.
Right, so the prohibition, I mean...
The fact that it's a prohibition is not relevant.
Okay, thank you. And then, of course, the third is the intangible of the federal government, which still looks upon marijuana as a Class 1 substance, which
Yes,
is illegal.
indeed. Yes, indeed. I
all
would
of-
have guessed.
All of this could be
Yes,
moot.
I would have guessed that the federal government had lost interest in marijuana, and because of all these states that are adopting statutes like this, and I would have guessed that the federal government had lost interest. Apparently, at least our new Attorney General has not lost interest. So what he's going to do about it, it's hard to predict. But yes, there is certainly the possibility that the federal government will sue the state seeking a declaration that the whole statute and the whole regulatory scheme is unlawful under federal law.
Excuse me, I was looking at the handout dealing with operating under the influence. Is there any test for that in Massachusetts?
I'm sorry?
Is there any physical or chemical test for driving under the influence?
My understanding is that there is not.
I didn't think so.
But perhaps one of these new testing labs will be able to come up with something. But in the meantime, there is nothing that's the equivalent of a breathalyzer or a blood test or anything that can be administered.
One additional question. Before my retirement, I represented a federally sponsored lender, and I know that they could not lend to this type of business. Can Massachusetts banks lend to it, or if they're federally insured or under the FDIC, are they prohibited?
I believe they continue to be prohibited from lending money. Many states, not yet Massachusetts, have also ruled that any lawyer that helps a marijuana business get going is in violation of the Code of Professional Responsibility.
That was my next question.
So there are a number of really difficult hurdles that would need to be overcome by a business before they can actually do this.
So the bottom line is it's privately funded.
That's correct.
Thank you.
I have 2 questions. For the on-premises consumption, would that just be for edibles? Because wouldn't the laws about smoking in public spaces supersede this, or no?
Yes, I believe that is that the smoking prohibition extends to whatever it is that you're smoking, and so it would be mostly the brownies and the candy bars and those things.
Okay, and then my second question was about the edibles, and it's what I know that edibles are allowed under the ballot question that was voted on, but what might or might not happen going forward? Do you have any ideas?
Well, I suspect that the regulations will require some form of labeling, which maybe at some point we could get good enough that the labeling might be able to articulate the important chemical composition of the brownie or whatever. The problem is that unlike a lot of other things, marijuana comes in all kinds of flavors, and in particular all kinds of potencies, and so it's not good enough to say this thing has, you know, a hundredth of an ounce of marijuana in it. That's not a useful label for anybody. So I assume that there will be a labeling regime, but it's complicated how they're going to do it, and especially if the testing facilities don't spur up on their own, it may be difficult to get compliance with these things. Another reason why the regulations might not be able to be ready as fast as people are imagining.
Do you know if there's been much conversation about the packaging? Because especially in terms of marketing towards children and packaging that looks like candy and things like that.
I have heard that the CCC will be interested in that issue, but CCC doesn't exist. The members have not been selected or appointed, so predicting what they will do is a little, I mean, a lot of this is guesswork, but now we're in the deep recesses of guesswork.
I have a question over here. The local option tax, is that going to be adopted the same way the local option meals and rooms tax is adopted?
Yes. The statute doesn't really tell us how to do it, but that's a good way. Yep.
Thanks.
Do you, I know that we don't have a CCC yet, and we don't have regulations, but I have two questions about where things might go. One is, should we be anticipating that ultimately, unless the federal government intervenes, that we'll be seeing marijuana sold in the way that cigarettes are now in multiple locations as just another product, or will they be more like the medical marijuana model where there's a specialized store that has to have a license that's very burdensome to comply with the conditions? And secondly, since we don't have the regulations yet, is there an argument for a longer moratorium, say 6 to 12 months after the regulations are adopted?
Oh, well, look, I'm a lawyer. There's always an argument. Let's go back to I would say we know what the Attorney General will approve, which is something like 15 or 16 months. If you want to go further, as I said, I managed to convince the Attorney General once that 18 months was okay for medical marijuana. If you want to make the moratorium to be 6 months after the regulations, you could do that, I think. Our current Attorney General, and in particular the Municipal Law Unit, which does the actual approving, are very good about giving cities and towns as much leeway as possible. So as long as you can make a credible case for it, I would suggest that you probably can make that argument, and you probably be successful. If many of your towns have town councils who have good working relationships, I assume, with the Attorney General's office. I know I'm on the phone with them all the time. Whenever I'm contemplating something that I think is different from what's been approved, they're very good about giving, informal advice. So it's certainly a possibility. I know that they don't want to be approving moratoriums that are longer than they have to be.